This is attorney Ron Fry from the Fry Law Firm. Earlier today, Paul Manafort was ordered detained by a federal judge after his bond was revoked for violating the terms of his pretrial release. Pretrial detention can have a significant impact upon the strategy employed during a case, as well as the ultimate outcome. One big consideration in a criminal case is whether a defendant will be granted the opportunity to be placed on bail during the pendency of the matter, or whether the defendant will be detained pending trial or resolution. The stress, fear, inconvenience, and uncertainty that naturally accompanies a criminal charge is exponentially amplified for many defendants when they are detained during the pretrial process. This is especially true for first-time offenders who have no experience within the system, let alone within any type of institution or detention center or jail. Although every circumstance is different, detention generally has a negative impact upon both the defendant and the effectiveness of the attorneys involved. Communication between defense counsel and the defendant becomes extremely difficult and challenging. The logistics associated with setting up and scheduling meaningful meetings with a client at a detention facility raises logistical and administrative issues. Meaningful and productive communication with the client becomes much more time-consuming and more costly. Rather than simply meeting within the comfort of an attorney's office, meetings within the detention facilities can occur only after going through a series of security steps that take up valuable time. Depending upon the location of the facility, the attorney must travel for the meeting. In cases that are being billed at an hourly rate, this travel and the security checks that occur upon arrival at the institution can add significant increased costs. Rather than meeting within a comfortable law firm, meetings within detention centers are often within rooms that are small and cramped, little ventilation, no natural lighting, uncomfortable chairs, damaged tables. The privacy is very limited. The communication can often be heard through the walls. So again, every institution is different, but it's quite common to overhear portions of multiple conversations emanating from the various meeting rooms. Rather than being relaxed within the comfortable atmosphere of a law firm office where drinks and snacks are always nearby and you can take a walk outside if you need to, get a breath of fresh air, stretch your legs, relax. Defendants in pretrial detention don't have any such luxuries, neither do the attorneys. So for instance, if you're in a lengthy meeting and you simply want a cup of coffee, you probably won't have any access to anything of the sort. There may be some opportunity for those things, but these may seem like minor details, but the environment definitely has an impact upon the ability to focus for both the attorney and the client. Experts, who are often utilized within the criminal justice system, whether it's a computer forensic expert called in to conduct a forensic examination, a firearm expert, or a forensic psychologist conducting examinations for purposes of mitigation, experts can play a very vital role, and they're often notoriously expensive. When a client is detained, the experts and consultants on a case face many of the same logistical challenges that the lawyers face, and often many more. For instance, experts often have equipment or material that they need to bring into the institution to consult with the client or conduct an examination. They're often retained and billing at an hourly rate, so if it takes them an hour to travel to the institution, 30 minutes to go through security, 30 minutes to wait while the client's being brought in, and then another 30 minutes to exit back through security, another hour of return travel, that time and cost adds up very quickly, especially given the fact that oftentimes these meetings are set and experts and consultants arrive at the institution, and sometimes even lawyers, and then the meetings are canceled for one reason or another. Sometimes the jail just simply is on lockdown. So unexpected circumstances certainly arise, and the cost generally accrues to the client. Other inmates, pretrial detention is jail essentially, and jail, well, it's jail. So defendants subject to pretrial detention learn very quickly that their freedom has essentially been taken from them. Their ability to simply avoid individuals they would rather not associate with or be around is limited. They don't generally have any say in who they're assigned to live with. And as a result, those who are detained are often impacted by the fact they're surrounded by other inmates who they may or may not get along with. This adds to the stress of an already stressful situation. Defendants often feel isolated. They're isolated from their family and friends, and although visitation schedules can be approved, there's generally significant limits on who can visit, when they can visit, and how long they can visit. And Often, this visitation occurs between glass dividers or over a phone. The conversations are subject to monitoring, recording, so in essence, there's generally no privacy. And this isolation has an impact upon the defendant, who is often going through one of the most stressful times of his or her life. If a defendant was employed prior to detention, that employment almost always ceases at the moment of detention, so detained defendants are generally unable to earn income. And this is at a time when income may be at the most needed to finance defense lawyers, the experts, consultants, to provide for the family. So this can have a profound impact upon the direction of a case. Clients who are able to remain on bond and continue with their employment have many advantages. They're in a better position financially to defend their case. They have more resource, and they're in better positions with respect to mitigation. If a case is going to take 2 years to resolve, there's a great benefit to the defendant who can appear at sentencing or before the court and demonstrate a commitment to gainful employment and actual gainful employment despite the circumstances of the pending litigation. Judges often appreciate that, especially if restitution can be made, even if it's piecemeal restitution. Any amount can count towards that, and if the judge sees that good faith effort is being made by the defendant, that certainly can impact the decision at a sentencing hearing or other hearings on the matter. There's also the psychological impact. So whether a defendant's guilty or innocent, pretrial detention too often can take the fight out of a defendant. They often feel they're left feeling isolated, out of resources, disconnected, hopeless. And I suspect that the environment with which they're placed impacts their decision-making to a great extent. Again, not all cases or defendants are the same, but oftentimes defendants become anxious to reach a resolution as they await trial in a detention facility. And it's especially true when they've served a significant amount of time awaiting trial and may not have much more time to go if they were to accept a plea offer. So with respect to the Paul Manafort case, only time will tell whether pretrial detention will factor into his decision-making process, whether he will ultimately enter into some sort of plea agreement or go to trial, or whether he will choose to attempt to cooperate in some way with federal investigators. But the fact that the court found that these bond conditions were violated in the manner that they were violated, this certainly is not going to help his cause. Not at all. It doesn't help his credibility, doesn't help his trustworthiness. It sends no indication to the prosecutors that he's on the right path. It sends no indication to the court that he's willing and able to comply with court orders. It's a big problem, and it's going to impact and color a lot of the decisions, I think, in this case. So some really important lessons to be taken from this Paul Manafort situation. Number one, be prepared for the bond hearing. So bond hearings occur at the commencement of a case, at the beginning of a case, and it's important to have an attorney on your side who's there and prepared, who knows your history and characteristics, who understands the bond arguments that make sense for your case, and is prepared to make the best factual and legal arguments on your behalf to try to secure a bond that is reasonable and will allow you to stay out of jail and out of detention pending resolution of the case. Again, there's so many benefits to being out, and there's so many disparate effects to being incarcerated during that time. So it's important to be prepared for that bond hearing, and then following the conditions if you're granted release, not just following them, but knowing what they are. So it's important as a defendant, if you're out on bond, if you're out on pretrial release, you have to not only follow the conditions, but you have to understand them. If there's anything that needs clarification, it's important to get clarification now, because you don't want to unintentionally violate a bond condition and find yourself before the judge in this type of situation where the judge can revoke your bond. It's a very serious thing. It does not have a good impact on the court. As I said before, it goes to credibility, it goes to trustworthiness, it sends the wrong signals to everybody involved. So if you or somebody you know has an issue involving bond or bail in federal or state court and would like to speak with an attorney, please call the Fry Law Firm for an initial consultation today. We'd be more than happy to speak with you. Thank you.